Abusia, I hear Ghana politics avenue, so Abusia, Mama Yembo Rai in Semo. Abusia, so subscribe or not subscribe, no share, no IT or notification bell, so am I. Send semi political airline, so I need DP about Abusia, Mama Yenko in Semo. Abusia, a year Attorney General represent a year fast track justice be echo a year parliament FIA tribunal in Sembia or the two just another boy ama a judiciary system no. Say ye dim rao a year court on a boy ama my ascendibian etumi ako fast ama a ye minority omo abo a year in some no atwegu say a banisa a dear call back to ye olden days it's a yadi a beboa a year Ghana and by Busia no na ye top a lawyer a year a legitimate a then simbi a explanation be abetuja efa a year tribunal a year court fast track justice and I explain it and simbi akwanim say I know ye and you may be a beboa amaye ye judiciary system no I run it fast or the same betuja say I know cry if I galam say who sensem or why chichi or fa galam say one beboa my young ye or final judgment in them or the explanation be brave at the tuja Abuja Mumianko Ninko in Sema a year top lawyer a legitimate at the tuja a tribunal a fast track a justice no hereby the jaka also.
That the questions you asked are in the bill, so I'll share a copy of the bill with you. Yes,
because my learned senior has raised certain important matters. I think it's important that I intervene quickly to put the fear people have at rest immediately at once.
Thank you.
Yeah. You see, first of all, the National Democratic Congress in its 2024 campaign manifesto, which is the social contract we had with the people of this country, overwhelmingly endorsed at the poll, was the fact that we promised that we would put in place a proper mechanism for the establishment of the public tribunals. Consistent with the promise H.E. John Dramani Mahama made to the people of this country, steps have been taken to establish that. Fears have been raised. I've listened to my learned senior Abu Jinapo, and I've listened to Ambassador Michael Cray now. Those fears are without any basis whatsoever.
Why do you say so?
Legitimately, you can describe them as red herrings. No basis. Look, I have with me, and because you gave me the topic, prior to coming here, I went for the public tribunal bill so as to inform the public adequately on what the government intends to do. Let nobody put any information misleading here.
Thank you.
The tribunals are part of the 1992 Constitution.
Thank you.
And there had not been any amendment whatsoever till now.
That's true.
In fact, the only time we came close to anything like an amendment was what happened in 2002. That is the Courts Amendment Act 2002, which amended the Courts Act with the removal of the district tribunal only. And that was even in 2002. But the regional tribunal, as established by the 1992 Constitution itself, is still there in our books. The only thing that was lacking is how they will operate. It is that operational mechanism that this bill is seeking to fill and to intervene. And so if you look at the bill, and before the bill, look, like I pointed out, Yebi and Abalifo was tried at the regional tribunal here in Accra. Incidentally, the respected senior state attorney, Anthony Jambibi, he prosecuted that case. And my senior in Krabia Fadate was the lawyer for the accused persons at that time. That was when the NDC reported its missing money. And the matter went to the court. And incidentally, in that case, if you recall, Senior Nkrabia Efadate raised an issue about its jurisdiction, which the Supreme Court had the opportunity to consider. And the Supreme Court at that time, yes, referenced that the regional tribunals, yes, in fact, had jurisdiction to try those serious offenses, even though the money stolen belonged to the NDC. So that record ought to be set. Look, there in the Republic, even robbery were being tried at that time by the public tribunal. Now let's go back to the fears expressed by my learned senior. If you look at the public tribunal, the bill itself as we have it, and I want us to go to the proposed section 11.
Section 11?
Yes, okay. Of the bill as proposed.
Section 11
of the proposed. No, this one is the proposed.
Yes, the proposed bill. Yes, this
is
the
proposed bill.
I just put it all together. Yes, I'll send it to you.
Section 11 of the
2026 Tribunals bill.
Yes. So, senior,
do you have it now?
Yes,
I'm talking about Michael Quay Jr. Do you have it now?
Maybe no, I can share with.
We're ready.
I can share with him. So let me just proceed.
Please,
yes.
Go ahead. Yes.
Section 11 of the proposed bill. And just to ensure that everything confirms with the 1992 Constitution, this is what it says. Appointments of chairman of public tribunal and panel members. The fear he expressed relative to the panel members. And see what the bill says. 11.1. The president shall, acting on the advice of the Judicial Council, appoint the chairman of the public tribunal. B, the chairman of the district tribunal. So it is upon the advice of the Judicial Council.
So it's not the president.
It's not a whimsical, capricious. And in fact, this provision is the same as the appointment of high court judges. They basically lifted it verbatim with all the necessary modifications. Now, what happens to the other members, the other panel members, the appointment? That's 11.2. It said the Chief Justice shall, acting in consultation with the Regional Coordinating Council for a region and on the advice of the Judicial Council, appoint panel members of the Regional Tribunal. So where is the fear? Important constitutional safeguards. So the other members of the District Regional Tribunal are going to be appointed through the Chief Justice, having consulted the Coordinating Council of the respective region. That's for the Regional Tribunal. On the advice of the Judicial Council. Fair safeguard. Now for the District Tribunal, the panel members, the same 11.2 now says that when it comes to the District Tribunal panel members, one, the Chief Justice must consult the District Assembly on the advice of the Judicial Council. Just as High Court judges are appointed, Second Court judges are appointed. The same procedure had been what? Brought into this public trial. So they fear that maybe some NDC member working somewhere can be picked and put on the public tribunal. That fear is cured in the proposed bill. In this country, NDC, NPP have had even non-party members appointed to the apex courts, superior court judges, and they have delivered justice. That had never been a problem.
Because there are guidelines.
Guidelines. You can't act whimsical.
The law is the law.
Well, no. The last time that phrase was used, it became problematic. No. I would restrain myself. So let me just stick to the issues. So, Section 11 of the proposed bill, which deals with appointments to the regional and district tribunals, have provided enough constitutional safeguards against such whimsical and capricious application of the rules just to undermine. When I listened to my learned senior Abujinapo, it became obvious that as at the time he was speaking, he's not had the benefit of reading the bill. Because if he had the benefit of reading the bill, those concerns would not be raised. What are the fears? He, Abu, at the time he was MP for Damongo, at the time when he was Deputy Chief of Staff to President Nana Addo Dankwa Akufo-Addo, the president appointed a non-NPP person as a Superior Court judge. Was it legitimate? You had confidence.
Right, you want us to
Please,
remind you of your
No, I'm coming. I'm coming.
Don't go there.
No, the point I'm making is that, so what is the fear? What is the foundation of that fear? If you go back to the bill, it tells you, and I've spent the whole night combing through the bill just to ensure that we allay the fear of the public. Now, the innovations that I see in this bill, and Senior, Martin, with your guidance, if you look, I have some challenges why those particular offenses have been listed. Look, code of conduct and disciplinary rules. A member of the tribunal is subject to the relevant code of conduct and any other disciplinary rules, just to ensure that they don't misconduct themselves. It's here, section 14 of the proposed bill. Now, what is even interesting is that the innovations in this particular bill, and for me, the thinking outside the box, is that it says that when this public tribunal is trying a matter, okay, which involves specific, and the law is specific, it says that when it involves minerals and mining, this is how the tribunal should conduct its affairs. Profound. We don't have any such law so far. It says that when you are dealing with galamsey-related offense, and this is President Mohammed's commitment to the fight against galamsey, he said there shall be no stay of proceedings. It's in the law. Look.
Yeah, but
no, I'm coming, Senior. I'm coming.
The challenge.
See, session. No, Senior. No, you Senior. In one breath, please.
Just one
mode of trial. The mode of trial. Mode of trial. And then right to legal representation. It says, section 27(1), a person who appeared before the tribunal shall have the right to be represented by a legal counsel chosen by the person. Safeguard fair trial, Article 19. Here. Application of Evidence Act. The Evidence Act 1975, NRCD 323, applies to proceedings of a tribunal subject to necessary modification. Further rules of engagement. The tribunal may admit evidence whilst ensuring compliance with constitutional and statutory safeguards. Constitutional and
implied.
No, I'm even saying that beyond even the implication, this one is expressly provided for. Further safeguards. Now, another interesting one. Live broadcast of public interest cases before the regional tribunal. Live broadcast.
That is
Section 31. It says, proceeding before the regional tribunal which involves a matter of public interest, including an offense against the state, may be broadcast live. So that if the tribunal members are misconducting themselves, the whole world will see. No secrecy. You can't go and hide.
The courts too
No. But I'm saying that. So what is the fear? If at the end of the day, the whole public will see their conduct. No secrecy.
When the law says may, it is not obligatory.
But I'm saying that. You even want it sharp.
I want it to be changed to sharp.
Very well, very well.
Because of the experience I have.
Very well.
It must be
That's
sharp.
even good. Now, let me, I beg you. This one is important
take
for me.
a quick one from the president. We understand the president has just arrived in Lajo.
Okay.
I think, yes. For the second
He's the boss.
He's talking about the vultures again.
He's the boss.
Let's cross over now. Kola Kuche is with the president. Kola, tell us what's happening where you are, quickly. Yes. Please.
Deployment of the trucks, the dump trucks, has just started, just like His Excellency the President said yesterday. They were going to retool the task force led by the military to do the cutting of the debris and the silt. quite a huge number of them. We've counted close to about 15 trucks that have come here at the Alajo Enclave where he was yesterday. And the desilting and the clearing of the debris is ongoing. You can see right in your shot, we have the tipper trucks all over there. And then the loaders also as well. But I mean, I can tell you the amount of filth, stench, most especially that has engulfed the area, cannot be underestimated. It tells you the enormity of what the challenge is. The issue about cholera and all others have also come to play, especially the caution being sent to the public. But let me just try a bit and then engage the Minister for Local Government now, who there are some questions that we may have to put to him regarding where all this filth will be sent to. Good morning,
All
Honorable.
right, so my colleague Komola Kluche is there for us. We understand the president is arriving shortly. When he does, we would cross over to him right now. Yes, but this is just our coverage of the day 2 of this nationwide sanitation day. We're still live here on Key Point on TV3. We're live on 3FM 92.7.
Let me be on record of saying that I rather will use the word shall to make it obligatory on us rather than may, which presumes that it may be done or may not be done. Because the public hearing is very important. Because these are...
And I strongly agree with him. So that at least the whole public knows what's going on. No kululu, no libilibi, no laba. The other point is that if you look at session, and look, Alfred, I beg you, I'm taking small time because this thing is important that we clear the public conception about the public tribunal because of the misinformation that has been put out. With respect, if you look,
you have your time.
It says defense of accused person and preliminary objection. Just to ensure expeditious trial, it says that a person who wants to oppose a charge shall, within 10 days, so limited time, when the charge sheet is served on you and you have an opposition to it, within 10 days you must file it. What this bill is introducing is speedy trial. So the point where lawyers can deploy all our skills, wait and do, we want to cure it with this one. Now, even more profound is the minerals and mining processes. It says where a party to a proceeding in relation to a matter under the Minerals and Mining Act 2006 is dissatisfied with the decision of a tribunal in respect of an interlocutory application, a party to the proceeding may make an interlocutory appeal against the decision of the tribunal. During the trial, interlocutory appeal shall only be made after the conclusion of the case. So where, for instance, tendering of evidence, you have an objection, you want to appeal, you want to stay. It says those things you can't do it with the public tribunal.
You have to finish the trial.
You have to finish the trial. Then if you have interlocutory appeal, you consolidate all of them and you do. That is not what is happening with the current legal regime in criminal trial. Because at this...
Because I have an appeal that has not been set in 4 months.
And I remember, and I'll tell you, when I did the NCA...
The wheels of justice grind slowly.
No, but I recall when I was doing the NCA matter, we tendered in evidence and we raised an objection with it. So that objection was overruled, and I appealed it. And I brought a stay application before the Court of Appeal, Tanko, blah, 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 at that time. They said, look, yes, it's a legitimate basis for an appeal. However, the stay will be refused. This time around, the legislation is trying to cure that whole enterprise where you can only file the interlocutory appeal when the prosecution says we have closed our case, then you can do that.
Also come with time for them to determine the appeal. Because, and again,
so
when the appeal has not been determined, there must be a stay so that...
listen. Section 39(3) of the proposed bill says that an interlocutory appeal filed under subsection 1 shall be determined within 30 days.
And shall operate as a stay.
This one, it does not. Now, it says that, section 40, stay of proceedings. There shall be no stay of proceedings in the case under the Minerals and Mining Act 2006. So when it is a galamsey-related offense, and the public tribunal is doing it, it said that there shall be no stay.
So how fair is that?
No, but you see, this is a determination to ensure that criminal justice is administered speedily.
Yes, but again,
these are not legitimate. So I am saying that this bill introduces very innovative provisions to ensure that the things that we lawyers do, basically, you know, there will be a certain
cases. There
will be a certain cases.
Thank you. So let me just make this one. I mentioned here that he was talking about our galamsey. And you remember I said one of the things. One second. I need to make a point.
No, I'll come back to you.
Tribunals are trying to.
Political highway, so if I fast track justice, NPP for a minority for able to go when they explanation, deep explanation, top top lawyers at the Atuja, mother explain actually say, same a pepper, I'm a judiciary system no. Akoso, a business subscribing and subscribing, no I share, no I notification, but so am I. A business SMP, or Kwanswa, a debatuja, a business, Yadamasi.